Cuffy was aware of any statement made by the police. Ralston himself did not testify that he was aware of any statement made by the police. I should also add that he testified he was aware of no problem between his parents and the Aitkins. He testified that he had never spoken with Mr. or Mrs. Aitkins. He came to his parents' house purely by chance. I don't mention this in my brief, but the record shows that he stopped by at a friend's, and the friend had a gift for his mother, and he decided to go over to his parents' house.
But of course, if his parents weren't there, he wouldn't have gone.
There is no evidence that he would not have gone. That is the point I was trying to make. The point is that he went to his parents' house for an independent reason, which had nothing to do with his knowledge of their presence or not. There is no evidence that his parents spoke with him. Indeed, the only evidence presented on that issue suggests an inference that his parents didn't speak to him too often because he was not aware that the three relatives from England were even at the house.
Well, assuming the very best state of fact for the plaintiff, if he was aware that his parents were at the house and went to drop off the gifts, wouldn't a claim be stated?
Well, there's no evidence in the record that supports an inference that he was aware that his parents were at the house, Your Honor, because he specifically stated that when he went there, he would have liked to join them for dinner, but he wasn't dressed for dinner. In other words, he just didn't know what was going on. Now, if he were aware, I still do not believe, if he were aware that his parents were at the house, I still do not believe he states a claim because he was aware of no police assurance with respect to Mr. Aitkins. Mr. Cuffy had not reported any threat to Ralston in particular. Ralston was an adult. He lived in his own apartment. He was 26 years old. He had his own...
Need he be individually aware of the circumstances and need it to be demonstrated that he personally relied upon the statements by the police?
Well, I believe that the precedents of this court show that every person who is to recover from a municipality based upon a breach of a special duty of police protection or other similar protection, such as fire, must show some knowledge of the municipal statement.
What if he lived in the house with his parents, but no representation were made directly to him?
If he lived in the house with his parents, it would be a more difficult case, and that is the case raised by Cyril. I should point out, however, that there is no evidence in this record that even Cyril was aware of any promise of police protection.
Does he have to be? Does Cyril have to be aware, as taken as one who lives in the house with the parents?
Well, if he were a minor child, I would say that the answer would be yes. And certainly we
say yes? If a minor child would have to be, a 6-month-old baby would have to be aware?
No, I'm sorry, Your Honor, I meant the contrary. If he were a minor child, he would not have to be aware of the statement, and I think that comes under the authority of Florence v. Goldberg and Sorochetti, where minor children were held protected based on representations or actions constituting such representations, as in Florence, that inured to that were made to the adult but inured for the benefit of the minor. Cyril is a difficult case because Cyril is not a minor. Cyril was 24 years old. Cyril did not testify at trial because he had had some emotional problems.
Ms. King, what would be wrong with a rule that extended the benefit to those within the zone of danger, using an analogy from Boveson, rather than concentrating on the individual fact development of knowledge in one or in another? Wouldn't that be a better rule? And that looks at the foreseeability aspect, which is a restriction and limitation on the extent of municipal liability.
Well, the zone of danger rule would create a grave difficulty, which I believe is illustrated by this case. Now, what we had here was a melee. What was to prevent Mr. Aitkins' brother from joining in? There's some evidence in the record that his brother was nearby. What was to prevent neighbors from joining in from Mr. Aitkins? This might all have occurred within the zone of danger.
But in Bobson, we limited that to immediate family members. Why, picking up Judge Bellicose's question, why would that same test not be suitable here?
Well, the same test would not be suitable as applied to this case in particular because Ralston was an independent precipitating factor in this whole sequence of events.
That's a factual determination. We're talking about the rule that should apply to make it at least more appropriate to municipalities and to claimants to know where the liability should lie.
Well, the zone of danger, if such were to be the rule, it would have to be clear, it seems to me, that there were some facts in the record indicating what the definable zone of danger would be. Now, in this case...
Those who would be exposed to the threat of which the municipality was made aware.
Well, the municipality was not made aware of it.
Assume for the purpose of Judge Bellicose's question, that there was proof that the police officer, the unidentified police officer said, "We'll take care of everything, you can rest assured." Now, Judge Bellicose's premise is that those who have knowledge of that, the immediate family, those who would be in danger of the Aitkins attack, would now fall within that protective area.
Well, we don't have any evidence of those who would be in the immediate family, residing in the family residence. I could conceive of being within such a class where they are actually exposed to harm as a result of the police actions.
You see, your problem with that is just what you were trying to do in answering Judge Simon's question. If you talk about minors and then you talk about a family member in the same house, you've got a problem then in talking about someone who lives in the neighboring house of a family member who might walk over. Isn't it reasonable to impose a general rule with respect to the municipality or another tortfeasor, by the way, it doesn't have to be a municipal tortfeasor, that indicates a zone of family where there's a zone of danger, where there's a likelihood certain members of a family might be together exposed to a particular harm?
Well, I think that given the problems that municipalities face, given the violence that does occur in our cities, and given the general function performed by the police in this case of trying to calm a distraught citizen, I believe that to use a zone of danger analysis in this type of case would be a very serious mistake.
So what is your answer? There must be actual reliance on the part of any plaintiff to recover.
Yes, what we would propose, and now I'd like to mention I guess this in a way is my wish list argument. But I believe this would be the correct rule for this state, and I believe it is a necessary rule because we are starting to see these cases come in legion. And I think this court is aware of that because this court is probably the best prepared court that we have ever had in the history of New York State on the special duty of issue, and I include Judge Bellicosa because I know that he knows everything this court has done.
Well, now you've
Now-
got one vote, you have only 6
All
votes.
right. Well, I
I may
think
have
Judge
to
Bell...
recuse myself now.
Well, you haven't sat on one of these opinions, but I'm sure you've read them all. Now, this statement, this reported statement, which is totally uncorroborated by any document, by any action, by any other evidence of any kind, is an insufficient basis, in our view, to ground municipal liability for the failure to provide police protection.
To sufficiency of the evidence, we're talking about the legal test.
Yes, but I am saying that I believe the legal test in these cases ought to be, in conjunction with Mock against Rensselaer Water Company, that the actions of the municipality, and I include statements, have to go beyond what was proved in this case in order to ground municipal liability. And if you review the record, and I hope you will read pages 319 and 20 and 321, because that is where the statements occur that are the entire basis.
Your whole argument is grounded on sufficiency. I think what we're trying to get at is what kind of a rule you're urging.
All right, well, I am urging a rule that the type of proof offered here, that the statement of the unidentified police officer is so inherently unreliable, creates such a grave inducement that it is not sufficient. Now, that is my wish list argument. However, the court need not reach that issue. I believe that existing precedent clearly establishes that Ralston, who knew nothing about any police statement, is not entitled to recover.
Would the nature of the threat, the scope of the threat, have any relevance to the extent to which the liability might attach?
Well, I believe so, Your Honor, because, and this is an independent legal ground why I believe there is not legally sufficient proof that a duty was assumed which would have extended to the event that occurred here. The threat reported to the police was Mr. Akins was going to burn the house down or kill one of the Cuffys before the night was out. Now, Mr. Cuffy went home after that, having been assured only that the police would take care of the matter in the morning. Now, how was the fact that the police were going to take care of the matter in the morning going to prevent that threat? And do the police have to foresee that the following night, after the Cuffys have gone back to their ordinary life, after Mr. Cuffy has gone over to repair a plumbing problem and brought back a bottle of wine, and they're planning to go out to dinner with the 3 relatives, and they're all standing around on the sidewalk, they are not under fear, they are not under expectation of police protection at that time. How is that sufficient?
May I ask a question?
Certainly.
I gather from that summation that as far as Ralston is concerned, as a matter of law, the rule that you think we should adopt and the rule that would knock his case out is the rule stated in DeLong, in
Sarketti.
Yearwood, in Soroschetti,
Hellman.
and Hellman, those cases which really lay out an exception to the general immunity rule for municipalities in cases of this kind for
That is-
police torts.
That is correct.
Namely, the special duty exception. Now, that's the rule you go on as far as Ralston is concerned.
That is
What
correct.
about the other 2 plaintiffs?
Now, with respect to
What
the...
do you claim with respect to them?
All right, Mrs. Cuffy and Cyril were on the top floor of their house at the time this incident occurred. Now, I know that the Bain case is a familiar case to Third Department justices, and motion for leave to appeal was denied in Bain. In Bain, it was held that the fact that the decedent knew that the person about whom a complaint had been made to the police had not been arrested at the time he was killed, the fact that he knew that nothing had been done, precluded his recovery in reliance upon a special duty theory. Now, the same thing is true with Mrs. Cuffy and Cyril. When they were on the 3rd floor of their house, they looked out the window, they saw Mr. Akins there, they knew he hadn't been arrested, which the police said they never said they were going to do anyway. They knew there were no police cars out there. They knew there were no police stationed out there. They were not under any protection from the police at that time.
But they were put in that position because they didn't move.
The fact that they did not move did not require them to leave the safety of their house. The police, if the police put them in a worse position, I see my time is up, it only...
You can finish responding to this question.
I appreciate that, Your Honor. It only put them in a worse position insofar as they were in their house. But the fact that they were in the house did not require them to leave the house. I realize they did so for reasons that this court and a jury would view as humane, to help Ralston. However, the sister, Margaret, said that she stepped back. She didn't want to get hurt. Ralston told his mother, "Don't come out." Now, a municipality simply cannot be held liable for that kind of independent action taken by citizens. We cannot have a precedent in this court that will say the police can take care of everything,
Now you're
which
doing
is
more than answering the question.
which is what the judgment below does. Thank you very much.
Thank you very much. Mr. Seif, isn't there much to what Ms. King says with respect to opening the floodgates here and holding the
That is the
municipalities
very-
liable? When you have a situation where the allegation is simply that a police officer gave them assurances, police officer's not around now, no one knows who he is, unidentified, simple allegation of that sort?
I'll answer that. I'm glad you asked me that. In the first place, this court in Schuster, in response to the same type of argument by the city, stated, referred to predictions of dire financial, I'm quoting, predictions of dire financial consequences to municipalities are waived in our faces. and it didn't think that there was any sense to that.
Well, here, there's more than, in Schuster, there was more than just the amorphous
So- and-
concept of threat.
Judge?
Here you had a man who was a target.
Judge, here you had a family that was a target, and I'll show that in just a moment. Before I address myself to the statements made by the appellant's attorney, some of them are not sustained by the record. And before I give the rule which I believe you should adopt, which you've asked for, rather, before I give the reasons for that rule, let me give categorically what I wrote down as regards the rule, in answer to the question asked by several of the bench. Where a municipality is informed of facts that bring a class within the zone of danger and gives an assurance of safety, of protection, not safety, protection, to a member of that class, on behalf of that class, then I submit that there is liability. Now, I'll address my reasons. Now, this court's decisions show that there has been a gradually...
Even under your test, though, in this case, Mr. Seifert, isn't there a problem because the assurance was that things would be taken care of the next day?
And the next morning, and it happened the next night. They take care of the next day, and it happened the next night. The assurance in the record, and I've got the page references, are the next morning we'll take care of it. And it happened the next night. There was a time bomb sitting there.
Isn't there a problem with that rule as far as Ralston is concerned?
But no,
Because as I read Sorochetti, one of the rules laid down there is that there must be direct contact of some kind.
unfortunately, in Sorochetti, there was no direct contact. In Florence, there was no direct contact. This court saw no difficulty in
But
those
in
cases.
Florence,
It referred
though-
to also, when they speak of an unknown lieutenant, there was less in the Sorochetti case when they spoke to a disembodied voice
In
over a
Sorochetti-
911.
In Sorochetti and Florence, you had infants that were under the control and custody of their parents. Here you have two adult men, one living with his parents and one not living with them at all.
The man who wasn't living with his parent, it's a fact of life, a fact a
That's
jury
okay,
could...
I'm in favor of adult children living away from their parents, but I'm trying to get to the question of reliance.
I have two adult children who live away from me. I have adult grandchildren who live away from their parents.
And how exactly do you define the class that's protected within the zone of danger?
The class that's encompassed within the threat, that brings me ahead of myself. If you'll permit me, I'll come to that in just a moment, Judge, please. This rule has been continually evolving and expanding. The basic rule that is spelled out to date is that the cause of action must be based on more than a duty owed to the general public. However that extra evidence comes forth, whether it's by a court order or a promise over 911, nobody specific, a voice on the telephone, must be more than a member of a class with whom directly or indirectly, that's a member of a class, directly or indirectly, a relationship of some kind has been attacked. Now, I submit that various, no specific facts would take a plaintiff out of being a member of the general public. And it depends upon whether those facts exist in this case.
Mr. Seif, then, wouldn't one of the elements that the court should consider, and you and your adversary, in constructing this test in the municipal liability area where you're dealing with a special duty, if you're going to borrow the zone of danger aspect, which is a significant advancement and expansion of the rule of liability here, is it not? Can we agree on that to start off with?
No, because Sorichetti and Florence both held it's the class of person in danger.
Well, if you won't concede
Not
that, then
merely
I'm
the
going,
person,
if you won't
the
concede it, I'm
class of
going,
person.
if you won't concede it, I'll ask you to assume it, that it is an expansion. If it is an expansion to take the zone of danger test from Bolson into this area, should the court not be looking at some balances as they did with the immediate family restriction and certain other contemporaneous events?
No question.
And should they not therefore look at this and say, well, maybe there has to be something with respect to the municipality rising to the level of a higher degree of certitude on the documentary nature of the complaint or the assurance or things of that kind, which would balance the new liability that would be imposed?
Not necessarily so, Judge. Not necessarily.
But on a policy
We're
basis,
not
wouldn't it be
relying on
something,
Bolson.
on a
We're not-
policy basis, wouldn't it be something that would have to be seriously
Oh,
considered?
that would have to be considered on the policy basis.
How do you
That would have to be-
define, how do you define the class? I'm not leaving Judge
All right.
Bellicosi's question.
By the class, I say, somebody against whom a threat has been made, which was brought to the attention of the police
A
department.
specific threat to a specific person?
That's right, or a specific member of a class.
Well, now you say member of a class. In Westerberg, the class was everyone who was driving along Sunrise Highway.
No, but here, we've got much more specific here.
Well, that's
Much
what I'm asking.
narrower.
How specific?
I'll tell you how specific. The police records show, and I'm referring now to the record.
Excuse me, Mr. Seifert, I know, I'm sorry to interrupt you, but when I say how specific, I don't mean in connection with this particular case. I'm going back to, again, Judge Bellicosi's question with respect to defining the class. As you know, we have to articulate the law here.
no,
How do we say the class is defined?
In this particular case, I can answer that only this way, Judge. In this particular case, the police were informed that there were threats to kill one of the Cuffys, a Cuffy, quotes, a Cuffy.
So the class now is every Cuffy in New York?
No, I would limit that to the members of the direct family of the Cuffys.
Living in that neighborhood?
Not necessarily so.
Any Cuffy within?
Or who could be anticipated to come there.
Well,
A
cousin
Cuffy
from
who could be
Westchester?
expected, foreseeable that a Cuffy directly related to these people. This man was, Aikens, the record showed, was irrational. The police were told facts that showed he was irrational.
May I try to define your class for you,
Yes,
if I understand it
I'd appreciate it.
correctly? That your class would include all members of the family, if one or more members had received a direct threat and had transmitted that threat to the police.
Not necessarily.
All right, wait a minute.
I'm
All members of the family, whether or not they knew of the threat and whether or not they knew of any reliance or any statements made by the police.
Whether that particular person knew, yes. Florence and Sorichetti.
All right, now may I ask about Florence, because I see a special class having a direct duty owed to them imposed by statute. The education law and the vehicle and traffic law carved out a special class of people who were the recipients of that duty, the mothers whose children would go to the points to be picked up by buses. And where is the duty here to someone who does not know about the threat and does not know about any transaction with the police?
This, Judge. The police were informed of the threat against a member of the family. The police was foreseeable to the police that a member of the family, close, a son, close, would visit the parents. That's not unknown, it's frequent. The police promised to take action, assured the people. They did more. They said, don't move, we'll take care of it. They prevented the Cuffys from moving and thereby prevented the Cuffys from notifying their son not to come to visit them.
For moving out of that house.
That's right.
So why don't you limit the class just to the Cuffys living in that house?
Because the threat was addressed to all Cuffys. And that's a Cuffy who foreseeably would go, a Cuffy who foreseeably, reasonably foreseeably, would visit his parents, a son of the
As
family.
I read the record, Mr. Seif, the testimony here was that the threat was that he was going to burn down the house and kill one of us before the night was out. Now, does that reasonably foretell that a member of the Cuffy, page 318?
No,
A member of the Cuffy family, not a resident in the house, is within the scope of this
At
zone of
one
danger?
other place, there was testimony that there were threats against killing one of the Cuffys.
Well, he says,
Cuffy.
and kill one of us before the night was out.
No, generally, at another place. At that place, yes, before the night was out. Then they would need no
So
protection the
you
next morning.
would delimit the scope of the class as defined by the threat. Is that correct?
That's right.
So if the threat could reasonably be limited only to the members of the Cuffy family living in the house, then you would say that Ralston would be outside the
If that
zone of
would
danger.
be, if that would be your construction, I'd be bound by it. It would be one
That's not too
construction.
charitable of you, Mr. Seif.
No. I've been bound by this court plenty of times.
We finally got a concession out of you.
Oh, I thought I'd been making concessions to stay along.
Mr. Seif, it was
Incidentally.
certainly known by the next evening, was it not, when Mrs. Cuffy left the house?
Yeah,
that
this
the
was
police-
early evening.
Yes,
Incidentally,
that the police had not taken care of it.
incidentally, there's another thing on that subject which is important in this case. There is something on that subject that is most important on this case. A charge that the defendant acquiesced in. No objection, no exception, no request for a further charge. The charge was read to the defendant before and given in that language, told the jury that it should consider the Cuffy family as a unit. That what applied to one applied to the family. At 637 and 638, the charge was whether the Cuffy family relied on the assurances of the police. At 636 to 637, that the plaintiff must prove that the police undertook to protect the Cuffy family. At 638, that the police were negligent in carrying out the duty, quote, to protect the family. 638. Under that charge, that bears out, I didn't realize it, that bears out what I had before. Now, may I say, just briefly, the police records, starting with May, show that the police knew that both Aikens, several times, had threatened to beat the Cuffys and had assaulted one of them. There was additional evidence that they knew that conduct required police intervention. May I have 1 minute more, Judge?
Yes, just finish your thought,
Yes.
please.
Both Mr. and Mrs. Cuffy told the police on the evening of the 27th that Aikens had threatened to kill a Cuffy, had assailed one of them with a machete, and assaulted and bloodied another one. The officer came to the scene and told the Cuffys the police would take care of everything. However, it was after that that there was a definite assurance when Mr. Cuffy went to the station house that there was a threat to kill, quotes, one of us. And the Cuffys were moving away. And it was the lieutenant who told the, Mr. Cuffy that the family should not move away. Had the family moved away, they no doubt would have notified Ralston. And no doubt, because they knew.
And certainly Ralston wouldn't have been there.
That's right.
Thank you very much, Mr. Stein. Matter of
I
Rowe.
never got around to the statements made, I said I'd cover.
Well,
But
it's all set forth very well in your brief. Thank you.
My name is Robert T. Rowe, and I'm pro se on the brief.
Yes, Mr. Rowe.
This is an appeal from an order of the Appellate Division, Second Department, which was entered in 2/28/86, denying the appellant's application for reinstatement as an
Mr.
attorney.
Rowe, excuse me, there is still an outstanding adjudication of incompetence here, is there not?
An outstanding adjudication of incompetence.
In other words, there's still a court order out there of incompetence.
Just that there be a mandatory supervision of psychiatric care. In other
Right.
words, therapy.
Right, there's been no finding or adjudication or court order determining the contrary.
No, not to date.
Well, let me just pursue that for a minute. There's never been a declaration of incompetence as such, there's never been a committee appointed.
No, that never has been.
There's
Yes,
been a
this incompetency
there's
is
been a
it gets-
finding of disability, which resulted in the suspension, and the only issue would be whether the disability has ceased, not a court order vacating a finding of incompetency, isn't that so?
Yes.
But there is the outstanding order of disability.
Yes.
Well, I don't want to argue with you about the record, but you've been released from the hospital, finding you're not at...
Yes, I'm out among the living and moving around and doing lots of things, right. And I signed contracts and leases and what have you. I mean, to that extent, there is no incompetency. I am under a court order to go every 2 weeks and to be monitored. Basically, it's a monitoring, I feel.
And wasn't there a motion by the state to discharge you from psychotherapy?
Yes,
Which was denied?
no, that's not correct. That's in the appellate's brief, but that is not correct. There is not a final determination of that. I do not have the proposed order yet
What is
in my...
the status of that motion?
The status of that motion is a situation where, well, I guess it's best to explain what happened on the day of the hearing. I was prepared for a hearing. I did not bring the motion.
It was by the state.
It was by the state, through the Attorney General, for the Commissioner of Mental Health. I kind of co-movement, I guess you would. When we got down to the hearing, the state withdrew that. And this is on the morning of the hearing. So we got together and there was an agreement. It's kind of a complicated agreement as far as I'm concerned. It's an agreement that the order would be extended for 1 more year for the mandatory supervision or monitoring. But that, well, that's about what it would amount to. At that time, I could at any time bring my own action, because I didn't bring the motion. I could at any time bring my own motion, I wouldn't be prejudiced any time within that year period that was
And
extended.
Are we still within the 1 year period?
Oh, yeah, sure, as a matter of fact, they do not have a copy of the order yet. It might be subject to resettlement, because the agreement is complicated. There's a lot of time frames in there. The appellate division denied my motion for reinstatement with no opinion, which really brought me into this court. The appellant was admitted to practice law on 12/1956 and was practicing 22 years without incident before a suspension. On February 22nd, 1978, 9 years ago, the appellant killed his wife and his 3 children. ages 7, 12, and 14, after a period of about 2.5 years of a slow mental deterioration. I mean, because Mr. Dewan has gone back into kind of the history, I should say that there were 2 very ill children involved. One was a deaf, mute, blind, retarded, who could not walk until he was quite like 7 years of age. This put tremendous pressure on the family, my wife, myself, and my other son was also sick. He was on crutches for 3.5 years. It was just one of those things, and at the time that the nervous breakdown came, or rather the incident of February 22nd, 1978, there was a juxtaposition of many things happening, career-wise, money-wise, which resulted in what can only be called a disaster. The trial was swift for the homicides, and I was acquitted on the grounds of mental disease and the defect, and the same day the appellant was declared incompetent by Justice Hyman Barsha and committed to the Custody Commission of Mental Health. The appellant's suspension followed on 10/27/78 without any hearing, and was based solely on the incompetency which arose pro forma out of the successful insanity plea. And
I
was
take it
committed-
your position is because you were suffering from a disability and not declared incompetent, but all you had to do was prove medically that the disability had ceased.
That's right. There are only 2 issues in this case. One
And
is
did you think that you submitted a prima facie case?
Absolutely.
That the disability had ceased, so the hearing was required?
Absolutely. First of all, I'm taking the position, to move on, that when Judge Oswine released me from hospital custody, that was a prima facie case of competency, because the only thing that got me suspended was the mental situation. There's no ethical problem. There's no morality. There's no strict intellectual. It's strictly a mental problem. Most people don't come back from this kind of thing.
Many people are released under those proceedings.
Yes.
Who are still suffering some mental
Absolutely.
problems, but who don't represent a danger to themselves or to the community. But that's not to say that they might be perfectly able to practice law without exposing their clients to some dangers.
Your Honor, there are many attorneys practicing law who are under therapy.
I'm just addressing the question of your prima facie showing, that's all. I don't know that you can stand on Judge Oswine's order
That's part of it, but I think that is I think this is very significant. Certainly, he wasn't releasing an incompetent into the general public. In addition to that, I have a medical certificate from the then doctor, physician, who was at the head of the treatment team that was treating me for this mandatory type of
Dr.
situation.
Jacques?
Dr. Jacques. Now, unfortunately, because of financial problems and what have you, I have to rely on public psychiatry for my doctors. This is quite a problem, because Dr. Jacques, these people are always leaving, and sometimes I'm just ready to go and somebody leaves. Now, he left, and the best report that I could get was several months later than I would like to have had it. However, he takes a very strong position that I had come back very swiftly, spontaneously almost, in May of '78. That was before I was suspended. So I'm working that into the fact that there was no hearing there.
May I go back to something you said earlier? You're still under treatment and still under order for treatment, I gather, periodically?
Yes, this is a very complex question as far as I'm concerned.
But I gather from what you said, this order that directs treatment goes on for a year. It's a one-year order.
That is if the order that comes back we all agree on is what's framed
So
in the agreement.
it's perfectly possible, I gather, that you can renew the motion and that at some time there will be an order discharging you completely from treatment.
No, it even goes further than that. The agreement is that I can do something tomorrow. I can start my own proceedings within that year
Two.
period. That's
And you
part of
have
the
not
agreement.
done so.
I have not done so because I don't have a final order down from the court. I really don't know.
When, as and if you get such a final discharge, then there would be nothing to preclude you from applying again.
I'm sorry, I
Would
don't
there?
understand
The
that
facts would
question.
be different. There would be nothing to preclude you from making a new application for reinstatement based on complete release.
That is true, but I'm taking the position that the mere fact that somebody is taking a therapy, that he can practice law. I don't see anything wrong with that at all. My own treating psychiatrist goes regularly to a psychiatrist. I mean, I think that says something. Oh, it's the truth, and he's on record in court on that. In addition to Joswine's order, which was as a result of exhaustive psychiatric, Creedmoor had to back that up with all of their doctors to get me down to that court, and then Judge Joswine assigned 2 independent psychiatrists who came out completely in my favor. So I think that is a much more persuasive type of an order than the pro forma order that put me into commitment as a result of the insanity plea. In addition to that, I have many affidavits. Mr. Dewan doesn't think too much of my affidavits. He talks of them as letters or something from my associates, but they come from attorneys. They come from a renowned doctor. They come from a professor. People that just don't go out and sign that type of a document. You could probably get money from a relative easier than have an attorney sign an affidavit in some proceeding like this. I have shown a tremendous amount of voluntary work that I do. Not that that's any different from before this incident. That is the end of my talk.
Thank you very much,
Thank you.
Mr. Rowe. Mr. Dewan, why shouldn't there be, at least based on the showing, a clearing and a hearing? And on clear and convincing evidence of the removal of the disability, he could be reinstated. What is the danger in allowing a hearing?
It's our position that on the papers presented, on the record before the appellate division, there was not even that prima facie showing that Mr. Rowe had shown that by clear and convincing evidence that his disability had been terminated or that he was now fit to practice law. To the contrary.
You have to make a prima facie case by clear and convincing evidence?
Well, there is nothing in the statute. We can look to the court rule. The court rule says very clearly that it is an application by the suspended attorney to be reinstated. It's not an application for a hearing. It's merely an application to be reinstated. It's our position that what he showed was that he was still under court-ordered psychiatric care, and that as such...
Is that the key element? If that were out of the picture, would the result be different?
If that were out of the picture, I'm certain that I can only suppose that the application would be treated differently. Mr. Rowe
Well,
tries...
you sort of swept them into subdivision A of the regulation, as sort of claiming that he's really incompetent, and there's got to be some formal judicial declaration that he's no longer incompetent. But that isn't really why he was suspended. He was suspended because he was suffering a mental disability under subdivision B, wasn't he?
Well, he was also involuntarily committed to a mental institution. There is also that provision in the court rules.
And he is not any longer.
No, he's not. But Mr. Rowe bears the burden of showing by clear and convincing evidence
Okay,
that
that's a
disability
different-
has been
that's a different
terminated.
thing. That's a different thing than requiring some court order from him now saying you've got a clean bill of health, isn't it?
Well, if the mere showing that Mr. Rowe had been discharged from the mental institution was sufficient, then in 1980 when he was
I'm not
released...
claiming it was sufficient, but I'm saying that having been discharged and having never been declared incompetent, can he not proceed to show by evidence that he is no longer suffering from a mental disability and request a finding that he's entitled to go back and practice law without ever getting a court order?
Well, It's not our position that that is required. It's our position that what was shown was insufficient for the appellate division to make that.
Well, is the fact that he is still, you mentioned he's still under psychiatric care, is that a factor that demonstrates lack of fitness?
It hasn't even risen to that level of judgment. I think the mere fact that he is still under court-ordered psychiatric care for the original disability that led to the suspension.
Mr. Dewan, what must he do in order to get a hearing?
The court rules merely state that he must show by the clear and convincing evidence that his disability has been terminated.
How does he do that? Affidavits of more psychiatrists?
I can imagine that the appellate division would take into account a current psychiatric evaluation from, for instance, the psychiatrist who is currently.
That's clear and convincing
It
evidence?
is. I can't characterize
Well,
what would be.
Wouldn't a hearing do it, really?
Well, there's no certainty that a hearing would show that.
Well, you're suggesting then that the submission on the application must be sufficient to demonstrate by clear and convincing evidence that there is an ability to return to practice.
Well, that the disability has been removed. That's.
But then there's no, you're saying that there's never going to be an opportunity for a hearing.
Well, it's not that at all. I believe that it's a question,
Shouldn't the standard be different with respect to what triggers a right to a hearing and what will result in a reinstatement, a granting of the petition?
I don't believe so. I believe that the standard is adequate and it's appropriate under these circumstances and under most circumstances of attorneys applying for application for reinstatement.
What is the standard to grant a hearing? Exactly.
There is no provision in the court rules
What
that
do you
there
say
be a
it should
hearing.
be?
I believe that if there are questions of fact that, such as the ones that were articulated in the matter of mayors by the First Department, where the appellate division felt that before reinstatement should be granted, that there should be a determination as to whether there was a restitution question. There was also a question as to whether the effect of his alcoholism would continue to affect his ability to function as an attorney. There were questions of fact that needed to be determined. Here, I believe that it's a question of what is on the application. I believe the focus should be on that application.
Mr. Dewan, are you saying that the appellate division exercised its discretion properly in denying the hearing, or that they found that there was no basis on these papers as a matter of law to have a hearing at all?
Given that the decision was not specific, I can't answer that.
Does it make a difference in terms of how we review it, though?
In an ideal world, the appellate division probably, it would have been better had there been a clearly articulated reason for the basis of the denial. However, I can't argue strongly enough that on the record presented to the appellate division, Mr. Rowe had failed to sustain his burden of proof. And
What more could anyone similarly situated do in order to earn a hearing, at least?
show that the disability, which had, according to psychiatric records and according to court records from 1978 and from 1980, that disability had been removed.
In which
Wouldn't
case
that
you would have been
entitle-
entitled to reinstatement,
Sure.
rather than a hearing.
The court rules also provide for the appointment of medical experts who can examine the applicant attorney and then report back to the court. This court declined to exercise
Is
that
that your
option.
fallback position, that we should reverse and remit to them to have such experts appointed and provide a hearing in the context of listening to that evidence as well?
I believe that if that were to be the effect of this court, that the fact that there is still that outstanding judicial adjudication that has not been finalized I believe that would prevent, or should prevent, the reinstatement. It's my position that as long as Mr. Rowe remains on court-ordered psychiatric care, that should be an effective block to his reinstatement. At this point, Mr. Rowe attempts to categorize that court-mandated psychiatric care as mere therapy, and I would submit that it goes well beyond the mere therapy that millions of Americans indulge in, and it's not merely for the purpose of bettering one's self-image, et cetera.
You're saying...
How do we know that? Excuse me.
That this is mandated by the court. In 1978, Judge Barchet, who found that he was not guilty, that he acquitted him by reason of mental disease or defect, that was based on a great deal of psychiatric evidence.
In actual fact, Mr. Delon, we don't know whether that was the reason or was not the reason. I mean, we're just speculating that might be the reason that he was denied hearing.
Well, unfortunately, as I stated before, the court decision is not clearly articulated, but it's our position that if one re-examined that application, the original application, that the result would be the same. And Mr. Rowe has also consistently misrepresented the implications of Judge Yoswine's 1980 decision. He continually characterizes it as a judicial finding of competency, and it was not a judicial finding of competency. It was merely Judge Yoswine's decision that he remain in psychiatric care as an outpatient because the district attorney had failed to show that he was still dangerously mentally ill and in need of further inpatient psychiatric care. And it merely changed the location of his treatment, and it did not state that the disability had been terminated. And that, I believe, is
If there had been an order obtained permitting discontinuance of all treatment, would that entitle him to a hearing as a matter of law?
I can't answer that as a matter of law. I can merely state that would probably then raise the next question: is he fit to resume the practice of law? Because there are two questions: has the disability been terminated, and is he fit to resume the practice of law? If there are no further questions.
No,
Thank you.
Thank you.
All please rise. Hear ye, hear ye, hear ye. All persons having any further business before this Court of Appeals, held in and for the State of New York, may depart hence, and appear here tomorrow afternoon at 2 o'clock, at which time this Court now stands adjourned.